Good afternoon, Vande Mataram, Jai Hind. Welcome to Chintamani 9617 online learning platform. Today we are going to learn about the citizenship, how we get the citizenship of India, other parts of the citizenships, and also the Citizenships Act CAA bill as well. So without wasting time, let's start. So what is citizenships? Citizenship is in the part 2, covers articles 5 to 11. The constitution confers the following rights and the privilege on the citizens of India and denies the same to aliens, means other people other than the citizens of India. Rights conferred under article 15, 16, 19, 29 and 30. We'll learn about that as well. Right to vote in election to the Lok Sabha and the state legislative assembly. Only citizens of India are eligible in voting in election of the Lok Sabha and the state legislative assembly, not in Rajya Sabha. Right to contest for the membership of the parliament and the state legislative, means we can participate in the membership of the parliament and the state legislature as well. The eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of Supreme Court and High Courts, Governor of the state, the Attorney General of India and the Advocate Generals of the states. For all these you have to be citizen of India. Then the article 5 to 8 only deals with the citizenship of individuals who became citizen of India at the commencement of the constitution, means the people who will get the citizen of India when the constitution is enforced. Also these articles are take into account migration issues. No person shall be a citizen of India or to be deemed to be a citizen of India if he has voluntarily acquired the citizenship of the foreign state. Means if I am a citizen of India but I have taken the citizenship of America, then my citizenship of India will be cancelled. That is noted in the article 9. Every person who is or is deemed to be a citizen of India shall continue to be such citizen subject to the provisions of any law made by parliament. That is in article 10. That means if I want to be citizen of India, then there are some provisions by law made by the parliament written in the article 10. We will learn about that in upcoming slides. Then in article 11, parliament shall have the power to make any provisions with respect to the acquisition and termination of citizen and all other matters relating to citizenship. Means parliament has the power, upper hand over the who will get the citizenship and the termination of the citizenship and the laws related to it. Hence the parliament enacted the Citizenship Act 1955, which has been amended in 1986, 1992, 2003 and 2005, and the most recently in 2015. The amendment bill 2016 is still pending though. The Citizenship Act 1955 is amended in various time to modify it. Then it comes the 5 methods for acquisition of citizenship as per the Citizenship Act, means how we will get the citizenship of India. First by birth, then by descent, then by registration, then by naturalization, by acquisition of any other territory into the Indian Union. And the loss of the citizenship is by termination, renunciation and deprivation. India provides for single citizenship, that means only citizenship of nation, not of the state. PIO, the person registered as PIO card holder under the Ministry of Home Affairs scheme dated 19/8/2002. We learn all these one by one. Before that, OCI. What is OCI? The Overseas Citizen of India. Under the Citizenship Act 1955, the OCI scheme is operational from 2 December 2005. Now both the schemes have been merged with effect from 9th January 2015. Citizenship Act 1955. The Citizenship Act 1955 provides for acquisition, determination, and loss or termination of Indian citizenship. In this act, the acquisition, how we will get the Citizenship Act, the cancellation, the loss or the termination of Indian citizenship is written in the Citizenship Act 1955. Then the citizenship in the Constitution of India is mentioned in the part 2, and Article 5 to 11 deals with the concept of the citizenship. We have discussed all the details of that. Then how we will get the citizenship, single citizenship, that is, the Constitution provides single citizenship to citizens. The concept of single citizenship has been borrowed from the Constitution of UK. The single citizenship, that is citizenship of the nation, not the state or any part, we have borrowed it from the United Kingdom. The citizenship of India are only the citizenship of the Union of India. They don't have any separate state citizenship like the USA. Double citizenship, where the person is not only the citizen of the country but as well as the state. Thus, the person enjoys the dual set of rights, one set by the country and other set by the state. But India, we have only one citizenship, that is the Indian citizenship, borrowed from the UK. The citizenship of India can be acquired by, we have discussed this. Let's discuss this by one. Citizenship by birth. How we will get the citizenship by birth? Any person born in India on or before 26 January 1950 but before 1st day of July 1987, this person will get the citizenship by birth. On or after the 1st July 1987 but before the commencement of the Citizenship Act 2003, and either of whose parents is a citizen of India at the birth of the child. That means after 1st July 1987, either, that is mother or father, who is the citizen of India and the birth of the child is in the India. Those born in India on or before 3 December 2004 are considered citizens of India only if both of their parents are citizen of India, or if one parent is citizen of India and the other is not illegal migrant at the time of their birth. That means after the 3 December 2004, both the parents, that means mother and father, both have to be the citizen of India, and if not, either one mother or father citizen of India and the second father or mother has not to be an illegal migrant. Then come the citizenship by descent. What is it? The persons born outside India on or before 26 January 1950 but before 10 December 1992 are citizens of India by descent if their father was a citizen of India at the time of their birth. The person born outside India on or before 10 December 1992 are considered citizens of India if either of their parents is citizen of India at the time of their birth. That means anyone will get the citizen of India if on or before 26 January 1950 but before 10 December 1992 these parents, either father or mother, was a citizen of India. Then the child will get the citizenship of India. Then the citizenship by registration, that means you have to register your name, your time of birth, place in the register. That is by a person of India origin who are ordinarily resident in India for 7 years before making an application for registration. That means if you want the registration citizenship of India, then you have to live in India for 7 years before making the application for the registration. A person of Indian origin who is ordinary resident in any country or place outside the undivided India. A person who is married to an Indian citizen of India and is ordinary resident in India for 7 years before making application for the registration, same as the first point. But if you are married to the Indian citizen and you are living in India for 7 years, then the minor children of persons who are citizens of India. Then comes the citizenship by naturalization. Citizenship of India by naturalization can be acquired by a foreigner who is ordinary resident of India for 12 years, and other qualifications are specified in the third schedule to the Citizenship Act. That means if a foreigner wants the citizenship of India, then he has to reside in India for 12 years, and other qualifications are specified in the schedule of Citizenship Act. He has to be followed. According to the Article 9 of Indian Constitution, a person who voluntarily acquires citizenship of any other country is no longer Indian citizen. That means if I am getting or I want the citizenship of USA and I got that, then my citizenship of the India will be cancelled. Also, according to the Passports Act, a person has to surrender his or her Indian passport. It is a punishable offense under the Act if he fails to surrender the passport. That means if any person is getting the citizenship of any other country, then he have to surrender, means give the passport to the passport authority, and that means he is surrendering his passport, his citizenship, and cancelling all other particles. Any foreigner on becoming eligible can acquire citizenship by registration or by naturalization irrespective of his country or his community. A special provision was added after signing the Assam Accord. Assam Accord, the CAA bill, we know that. Though the Citizenship Amendment Act 1985, that every person of Indian origin who came to Assam on or before 1st January 1966 but before March 25, 1971 from Bangladesh and who has been ordinary resident in Assam since the date of his entry and registered himself in is deemed to be a citizen of India. The Assam Accord says that any person who came to India from Bangladesh on or before 1st January 1966 but before 25th March 1971 and he or her registered in the registrar, and he will get the citizenship of India. Then the citizenship by incorporation of territory. That means if India acquire a territory, a state like Goa, Daman, Diu, we acquired from the foreigners, then the people living in that territory will get the citizenship of India. If any territory becomes a part of India, the central government may by orders notified in the official gazette specify the person who shall be citizens of India by reasons of their connection with that territory, and those persons shall be citizens of India as from the date of specified in the order, provided that if in the opinion of the central government the applicant is a person who is rendered distinguished services to the cause of science, philosophy, art, literature, world peace or human progress, generally it may waive all or any of the conditions specified in the third schedule of the Citizenship Act 1955. The person to whom certificate or naturalization is granted shall, on taking an oath of allegiance in the form specified in the second schedule, be a citizen of India by naturalization as from the date on which that certificate is granted. The overall meaning of the citizenship incorporation of territory, that means if India acquire any territory, then the central government will place an order, will get the citizenship of India. But if any person is specialized or rendered distinguished philosophy, art, services caused of science and human literature as well, then there are specification terms and conditions for him or her. Then comes the laws of the citizenship of India. There are also some provisions for the laws in getting lost from the citizenship of India. like by renunciation. When a citizen makes a declaration renouncing his Indian citizenships, that means he is acquiring any other citizenship. By termination, Indian citizenship is terminated if any citizen voluntarily or consciously acquires the citizenship of other country. By deprivation, acquires citizenship by fraud if shown disloyalty to the Constitution of India, if traded or communicated unlawfully with the enemy during the war. The citizen is within 5 years after registration or naturalization imprisoned in any country for 2 years if ordinarily resides out of India for 7 years. These are the some parts that how you will lose your citizenship of India. Then comes the PIO and OCI, the person of Indian origin and overseas citizen of India. We have made some difference in that. The PIO means a foreign citizenship. Foreign citizens expect a national of Pakistan, Afghanistan, Bangladesh, China, Iran, Bhutan, Sri Lanka and Nepal. A foreign citizen whose one of the parents, grandparents, great-grandparents was born and a permanent resident of India. These persons are named as the PIO, person of Indian origin, who is spouse of India, citizen of India or a PIO. Then for the OCI, a foreign national who was eligible to become a citizen of India on 26 January 1950 or was a citizen of India on or at any time after 26 January 1950 or belong to a territory that became a part of India. These terms are given for the overseas citizen of India. The benefits of the PIO, the person of Indian origin. The PIO card holder do not acquire a visa to visit India for a period of 15 years from the date of issue of the PIO card. That means if you have a PIO card, then you don't require any type of visa to visit India for a period of 15 years for after the date of issue the PIO card. Then they are exempted from the registration at FRRO. FRO if their stay does not exceed 180 days. In case if their stay exceed 180 days, they shall have to register with FRO within next 30 days. They enjoy party with NRIs in economic, financial and educational benefits. All future benefits that would be exempted to NRIs would also be available to the PIO card holder. Then the benefits of the OCI, overseas citizen of India. They are entitled to a multi-purpose, multiple entry lifelong visa, allowing them to visit India at any time for any length of time and for any purpose. The PIO and the OCI are different. Exempted from the policies reporting or for any length of stay in the country. They can stay in India for any time and the length of the time is unlimited. Have also been granted all the rights in the economic, financial and education fields in the parity with NRIs except the right to acquisition of agriculture or plantation properties. These are some difference in the PIO and OCI. Then what is the overseas citizenship of India? We'll discuss this in a short. The government of India gives the overseas citizenship of India, which is sometimes mistakenly referred as a dual citizenship. A person of Indian origin PIO who have migrated from India and acquired the citizenship of foreign country other than Pakistan and Bangladesh are eligible to get OCI as far as their home countries allow dual citizenship in some form or other under the local laws. Ministry of Home Affairs defines an OCI as a person who was a citizen of India on or after 26 January 1950 or was eligible to become a citizen of India on 26 January 1950 or is a child or a grandchild of such person among other eligible criteria. In the year 2015, Citizenship Amendment Act 2015 merged the person of Indian origin category as the OCI. Then an OCI is a citizen of any other country. An OCI gets the multiple entry long-term visa for visiting. An OCI is not at per NRIs in all matters. And lastly, the OCI does not enjoy the privilege as the permanent citizens, such as they will not get an Indian passport, they will not allowed to vote, they do not have the right to contest the election, and they cannot become the member of either of the house or the state legislature. These are some differences, the OCI and the normal citizen of India. Also, they cannot hold the constitution post or any other post under the government of India. They cannot acquire the agricultural or plantation properties in India, but they can inherit such properties. What is the CA, Citizenship Amendment Act, CA 2019? All the drama that was going on. The Citizenship Amendment Act 2019 was passed by the Parliament of India on 11th December 2019. It amended a Citizenship Act 1955 by providing a path to Indian citizenship for illegal migrants of Hindus, Sikh, Christian, Jain, Parsis, Buddhists fleeing persecution from Pakistan, Afghanistan and Bangladesh before December 2014. Muslims from these countries were not given such eligibility. The act was the first time religion had been overtly used as a citizen criteria for the citizenship under the Indian law. This bill will amend the Citizenship Act 1955, which will make illegal migrants from the selected categories eligible for the citizenship. Also, the Act states that the specified class of illegal migrants from 3 countries will not be treated as illegal migrants, making them eligible for the citizenship. On acquiring citizenship, such migrants shall be deemed to be Indian citizenship on the date of their entry into India, and all legal proceedings regarding their status as illegal migrant or citizenships will be closed. The Act allows a person to apply for citizenship by naturalization if the person meets the certain qualification. One of their qualification is that person must have resided in India or been in a central government services for the last 12 months, that is 1 year, and at least 11 years of the preceding 14 years. For the specified class of the illegal migrant, the number of years of residency has been realized from 11 years to 5 years. That means if you are living in India for 11 years, there was a prior recommendation, the qualification for acquiring the citizenship, but it is now the 5 years you have to reside in India. However, it will not be applied to certain areas. These are the tribal areas of Assam, Meghalaya, Mizoram and Tripura, as included in the 6th schedule of the constitution. Second, the states regulated by the inner line permit under the Bengal Eastern Frontier Regulation 1873. These 6 scheduled tribal areas include Karbi along in Assam, Garo Hills in Meghalaya, Chakma district in Mizoram and Tripura tribal areas of district. Further, the inner line permit regulates visit of all persons, including Indian citizens, to Arunachal Pradesh, Mizoram and Nagaland. Before that, what is the CAA bill? I will tell you the CAA bill in a very short form that you will get to know about it. Firstly, the Citizenship Amendment Act. What is it? CAA, Citizenship Amendment Act 1955. There was a case of the clearance spy versus the Union of India in 2001. The Supreme Court has clearly mentioned that in case the government of India or the state if it is providing the differential treatment to a group of individuals whose any activity outside the territory of India has been going on, or giving some prior places, then it will not considered as the violation of the Article 40. And also the particular people, we know that the Hindus, Sikh, Jain, Parsis are given the citizenship of the country, but not the Muslim. This is because of the Muslim has the other countries like the United Arab, Afghanistan, the Pakistan. They can go there if they are not feeling secure in one country. But the Hindu, Jain, Parsis, the Sikh, they have only one country, that is the India. That's why the privilege has given to them and not from the Muslim. That's the only condition the Amendment Act is going on. And also this act is not applicable to the Assam, Meghalaya, Mizoram and Tripura tribal areas. They have some inner line permit, the Assam Accord. So the Bawar that was going on, they have misguided the people and given some other type of, all this flow. This battle was going on in India, but now the people have got the concept of these act and got to know about these. And also no one in India will be terminated from the Citizenship Act. This was misguided by some people, that if this bill or act got in the process, then the Muslim in India will have to move out. This was not the case. We will discuss in some other classes about the NRC and NPR. Let's now take further about our class citizenship. Then comes the citizenship. What is it? The population of the state is divided into two classes, citizenships, that we discuss about it. Then now let's take the look at the articles that I have told you, to 5 to 11, one by one respectively. The article number 5 states that every person who has a domicile in territory of India and who was born in the territory of India, or either of the parents was born in the territory of India, who has been ordinary resident in the Indian territory for not less than 5 years preceding such commencement shall be citizen of India. That means in the Article 5 it is stated that who will get the citizenship of India, that is, if I am born in the territory of India, then I will get it. Also, either of the parents, my mother or my father, is living in the born territory of India, then I will get the citizenship. Also, my father, mother or me is living in India for less than 5 years, then I am applicable for that. Then the article number 6 states that the person who has been migrated to the territory of India from the territory not included in Pakistan shall be deemed to be a citizenship of India at the commencement of the constitution if there are some clauses. Clause number 1 A, he or either of his parents or any of his grandparents was born in India and defined as defined in the Government of India Act 1935 as originally enacted. That means if me or either of my parents or my grandparents was born in India, the clauses defined under the Government of India Act 1935, then I will get the citizenship of India. Then the clause number B, in case where such a person has migrated before the 19th day of July 1948, he has been ordered resident of India since the date of his migration. That means if I migrated before the 19th day of July 1948 in the territory of India since the date of my migration, then I will get it. Or in the case where such a person has so migrated on or after the 19th day of the July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on the application made by him thereof to such officer before the commencement of his constitution in the form and manner prescribed by that government, provided that no person shall be so registered unless he has been resident in the territory of India or at least 6 months immediately preceding the date of his application. That means you have to give the proper application to the the officer appointed on the behalf of the government of India. Then you have to give the application and you are registered. Then the Article 7 states that a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be citizen of India. That means migrated from the territory of India to the migrated now in Pakistan, then he will not allowed deemed to be citizen of India, provided that nothing in this article shall apply to a person who after having so migrated to the country now included in Pakistan has returned to the Indian territory under permit for resettlement or permanent return issued by or under the authority of any law, and every person shall be for the purpose of the clause B of Article 6 to be deemed to have the migrated the country of India after the 19th of the July 1948. That means if I am going to the Pakistan, then I am not eligible migrated to the territory, migrated from the territory of India to the Pakistan, then we shall not be deemed to be citizen of India. But if I am coming back for the reapplying for the citizenship of India, then I have to follow the Article 6 provisions as well. Then the Article 8 states that any person who or either of those parents or any of whose grandparents was born in India as defined in the Government of India 1935. That means my parents, either of my parents or either of my grandparents was born in India as defined in the Government of India Act 1935, and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is or for the time being residing on an application made by him therefore to such diplomatic or consular representative, whether before or after the commencement of the constitution in the form or manner prescribed by the government of Dominion of India or the government of India. That means in Article 8 it is stated that if either of my parents or any of my grandparents has been born in India under the Government of India Act 1935, if I am living outside, that means my parents are living outside, I am born and I have registered in the diplomatic or consular representative of India, then I will get applicable for the citizenship of India. Then the Article 9 says that no person shall be a citizen of India or deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign country. That means if I am acquiring the citizenship of any other country, then I am not the citizen of India, voluntarily acquiring. Then the Article 10 states that every person who is or deemed to be a citizen of India shall continue to be a such citizen subject to the provisions of any law made by the Parliament. We have to follow the laws made by the Parliament for getting the citizenship of India, that is written in the Article 10. in Article 11 states that the Parliament shall have the power to make any provisions with respect to the acquisition, termination of the citizenship and all other matters related to the citizenship. That means Parliament has the upper power. Parliament have the upper hand for the provisions related to the acquisition and determination of the citizenship of India. The termination of citizenship, the first part is by renunciation. If any citizen of India is full age and capacity who is also a citizen or a national of any other country makes in the prescribed manner a declaration renouncing his Indian citizenship. In short, by renunciation means if I have a citizenship of one country and I don't want the citizenship of India, then I will just cancel it by making some application or by declaring that I am registered in the prescribed authority, that I am acquiring this country citizenship. I don't want Indian citizenship. This is written in the by renunciation, the termination of the citizenship. The same in this. Then by deprivation, the central government under Section 10 of the Indian Citizenship Act 1955 deprives any citizen of Indian citizenship if it is satisfied that A. The registration or certificate of naturalization was obtained by means of fraud, false representation or concealment of any martial fact. That means I have acquired the citizenship by a fraud. That the citizen has shown himself by act or speech to be a disloyal or disaffected towards the Constitution of India. That means if I am making any type of speech or any kind of act towards the unlawful or disloyal to the Constitution of India, then my citizenship will get cancelled. Also, that citizen has during the war, in war, if I am helping the enemy of my country, then my citizenship is cancelled. In D, that citizen has within 5 years after registration or naturalization has been sentenced. That means if after I have registered in the citizenship of India but I got arrested in any other country and sentenced for 2 years imprisonment, then my citizenship will get cancelled. That citizen has been ordinary resident out of India for the continuous period of 7 years. That means if I am a citizen of India but I am living outside the India for the continuous period of 7 years, then my citizenship will get cancelled. For that you have to come to India, get your citizenship renewed or live for India for some time, then you can go for another several years. Then the last part is the central government shall not deprive a person of citizenship unless it is satisfied that it is not conducive to the public good. That person should continue to be a citizen of India. That means central government shall not, central government will not deprive any person's citizenships if it is satisfied that the person is for the public good health. That person continues to be a citizen of India. These are the points that how you will get the citizenship of India, how you will get terminated, that means cancelled your citizenship of India. These parts we have discussed for the today, and we have concluded our topic, the citizenship of India. That was all about it. Thank you for joining me, and don't forget to like, subscribe and share. We will meet tomorrow at the same time. Thank you.